We are about to start. Our first plenary session is a presentation of the jail decongestion study by our GOJUST experts. Kindly be seated for this session, please. This jail decongestion study was undertaken by Attorney Romel Arbitria and Dr. Raymond Narag. This was conducted under the Justice Sector Coordinating Council, or the JSCC, with support from the Governance and Justice Program of the European Union. Ladies and gentlemen, Attorney Arbitria is the Executive Director of the Humanitarian Legal Assistance Foundation, or HLAF, and a member of the National Decongestion Summit Steering Committee. Dr. Narag is an associate professor at the Southern Illinois University in Carbondale, Illinois, USA. I have known Dr. Narag since my college days, just to say. So, ladies and gentlemen, please welcome Attorney Arbitria and Dr. Narag to the stage.
Good morning, everyone. May I request the tech team to please show the presentation? Do we have? So today, my colleague, Dr. Raymond E. Narag, and I will be sharing our study on the causes of jail overcrowding and the slow disposition of cases. Our research adopted a multi-method approach, combining quantitative and qualitative techniques to delve into this complex socio-legal issue. This allowed us to not only analyze statistical data, but also gather personal narratives, providing a comprehensive understanding of the factors leading to jail congestion and case analysis. As of December 31, 2021, there were approximately 199,079 persons deprived of liberty, which is equivalent to about 179 PDLs per 100,000 population. Notably, only about 30% were serving sentences, and an overwhelming 70% were under preventive imprisonment. Of the PDLs in BJMP, only 11% were women. And a significant portion, at around 69%, faced drug-related cases. Unfortunately, the figures that we present, while informative, don't fully represent the actual number of PDLs due to incomplete data, particularly from provincial jails and lockups managed by law enforcement agencies. In this slide, we see BJMP's jail population in orange bars, jail capacity represented by the black lines, and the occupancy rate represented by the blue line from 2011 to 2021. The chart illustrates a dramatic increase in occupancy rate in BJMP facilities, peaking at 690% in 2017. Despite a decrease to 357% by 2021, over-occupancy remains a significant issue, with some facilities housing PDLs at rates as high as 2,748% of their intended capacity. This means that 2,748 persons are occupying a facility which is just intended for 100 PDL. Overcrowding leads to dire consequences, including poor living conditions, heightened health risks, increased violence, and clogged court systems, all of which strains the criminal justice system's efficiency and effectiveness. To analyze the legal phenomenon of overcrowding, we employed the Capacity, Input, Throughput, and Output Framework, or what we call the CITO framework. Capacity refers to jail resources and space where overcrowding happens when the ideal capacity of 4.7 square meters per PDL is exceeded. Input encompasses factors leading to incarceration, such as law enforcement and pretrial detention. Throughput involves case processing within the justice system, where inefficiencies and slow processes contribute to overcrowding. Output includes alternatives to imprisonment and other disposition measures, releasing PDLs from detention facilities. Using the C2 framework, our findings suggest that the surge in occupancy rate from 2011 to 2017 was driven by aggressive law enforcement during the war on drugs and insufficient jail expansion. However, the decline after 2017 can be attributed to factors like the case of Estipona versus Lobrigo, which expedited drug case processing and increased releases by allowing plea bargaining in drug-related cases, the BJMP policies during the pandemic, which restricted the acceptance of new PDLs in BJMP jails, the Supreme Court policies on bail and release on recognizance, and number 4, the slight improvements in jail capacity. At the input stage, data shows systemic issues in law enforcement and prosecution practices have led to increased admissions and congestion. These include unlawful arrests, planting of evidence, and overcharging, and the study revealed that there were even female PDLs who were only arrested due to their association with male targets. Data showed that some criminal cases were still filed despite the insufficiency of evidence and the irregularity of the arrest because of the low threshold of proof in filing cases and the practice of conducting inquest proceedings as a form of empty compliance. Additionally, the lack of effective reintegration programs for former PDLs, contributory offending, and further overcrowding. Former PDLs often struggle with societal reintegration due to stigma and limited employment opportunities, leading to their recurrent involvement with the criminal justice system, further feeding into the cycle of overcrowding. At the throughput stage, data revealed critical factors affecting jail overcrowding. Overcharging of accused individuals with non-bailable offenses contribute significantly to jail congestion as it leads to unnecessary and extended pretrial detentions. Additionally, unresolved violations of Article 125 of the Revised Penal Code exacerbates the problem. The DOJ data showing an increase in court disposition of cases indicates a move towards efficiency. However, the average 567 days of detention highlights a persistent challenge in case processing. Data show that case resolutions are delayed by frequent postponements and lengthy interval between hearings. Additionally, the attitudes and practices of judges, coupled with the shortage of judicial personnel, significantly extend the duration of criminal cases. The implementation of the revised rules on continuous trial has shown potential for efficiency. However, heavy case loads of courts and the inheritance of old cases by new judges impede its effectiveness. Data show that reducing the case loads to a manageable level is a daunting task, which require countless collaborative efforts and overtime work on the part of judges, court staff, and lawyers. Another noticeable gap in the throughput is the need for continuous following up of cases, especially for PDLs lacking external support. Initiatives like the justice zones and the Task Force Katarungan at Kalayaan facilitate collaboration among justice sector agencies, promoting faster case disposition and potentially reducing jail overcrowding. Programs notably, law students involved in clinical legal education programs have played a crucial role in facilitating the release of eligible PDLs and preventing case stagnation, as evidenced by the humanitarian legal assistance work with law students from Ateneo de Manila University, University of San Carlos in Cebu, Ateneo de Zamboanga, and Ateneo de Naga. The study reveals the crucial role of a robust legal framework, including laws, rules, and guidelines in allowing PDLs to be released. Punitive legislations, which provides for non-bailable penalties, exclusion from parole, or good conduct time allowance, aggravate jail congestion by disqualifying whole sets of PDLs from being released based on the gravity of the penalty without regard to the risk that they pose to the community. In the Philippines, the range of alternatives to imprisonment is very limited. For instance, the law on recognizance intended to ease jail congestion is rendered useless because of its onerous requirements and complicated procedures. High bail amounts are also very restrictive, especially to indigent PDLs who can typically only afford about 10,000 pesos. Due to the lack of clear and detailed rules on alternatives to imprisonment, judges hesitate in releasing even low-risk PDLs. This cautious approach restricts PDLs outflow, thereby contributing to jail overcrowding. Imprisonment remains the default disposition, with judges often wary of releasing PDLs or reducing their bail amount for fear of appearing lenient, particularly in drug-related cases. On the bright side, data show that there is willingness among criminal justice stakeholders to consider alternatives to imprisonment. This is evidenced by the significant reduction in BJMP jail population following the case of Estepono versus Lobrigo and its accompanying plea bargaining frameworks. Similarly, the Supreme Court's rules on reduced bail and recognizance, providing clearer guidelines during the pandemic, saw judges more comfortable with releasing PDLs. This suggests potential for future reductions in jail populations, provided that there are clear and specific laws and guidelines. One unforeseen outcome of the plea bargaining framework, however, is that it resulted in some innocent individuals pleading guilty to obtain quicker freedom, preferring early release to support their families over languishing in prolonged detention in overcrowded facilities. These insights and practices have prompted us to propose targeted recommendations, which will be further elaborated by my colleague, Dr. Raymond E. Narag.
Thank you very much, Attorney Iop, for that very good description of the problems we found. And we used the C2 framework. And it's the same framework as well when we developed these different proposed solutions. And these proposed solutions came also from our interviews, from the court actors and correctional officers that we have interviewed. It also is an output of our review of the literature from other countries and what other best practices that they have developed. And right now we have also experts from Brazil and experts from Mexico and the United States coming here to provide further discussions on how do we resolve this endemic problem. So let me now say that this proposed solution is also a part of the efforts that I've heard from PDLs all over the country, PDLs whom I've slept in their cells with, PDLs who have grown with me into this process of our criminal justice system. All right, so what are the proposed solutions? All right, let me see if this works. Did it work? Oop. Okay, so one of the ways is that, let me go back. So this is, all right, so first will be decriminalization of certain offenses. As noted by my colleague earlier, we arrest people even by gambling, and these are people that are given a bail amount of 36,000, and they could not even be released because they could not make that funds available, and so they are now thrown to prison. And as mentioned earlier as well, there should be a way for us to decriminalize some of our drug laws, especially those that are not translating into violent offending. And as we have mentioned, the DOJ have come up already with very innovative solution, and we need to support this. And this requires that the probable cause be increased to prima facie evidence with certainty of conviction as the basis for filing of cases. We have also looked at other countries, and in other countries, they have what we call custodial hearings. That when a police arrests an individual, a custodial hearing conducted by the judge immediately to determine whether they require detention or they could be released at that same instant. Of course, as mentioned already, we have to introduce alternatives to detention in incarceration, like adult diversion programs that is very similar to the ones given to our juvenile diversion programs. And as my colleague Roy, Attorney Roy, later on, he will discuss mechanisms for alternative dispute resolutions, because not everything had to be met in our criminal justice system. Basically, what we're saying here is that detention should be used as the very last resort. We should use it only for those individuals who are considered high-risk reoffenders. In many countries, especially in the United States, they have what we call pre-trial release programs. And what does this do? So in correctional management right now, we introduce what we call the R&R principles, the risk, needs, and responsivity, where you identify the big 8 factors like criminal history, family, peers, and other risk factors that lead to offending. And the higher the risk, you will be put in detention temporarily, but if you are low-risk first-time offenders, you are going to be released through supervision. And I'm very happy that we have introduced this in the BJMP. They have now their assessment and classification units, and also with the parole and probation with their CARAT. Soon, we are going to have also the Bucor BRINE, which is the Bucor Risk and Needs Evaluation. We also found that there's a huge problem with our bail system. America and the Philippines are the only 2 countries in the world that have a commercial bail system. In many countries, they have done away with the financial bail system. So probably we have to review that. And the efforts by the DOJ secretary were those indigent and could not post bail, we put a cap limit of 10,000 pesos. If this could be codified, we found that, especially in Quezon City Jail, for example, of the 4,000 PDLs there, we could release automatically at least 1,200 PDLs using this framework. A very immediate release of many people. And as mentioned already, we need to review the release on recognizance law. Only 3% of our releases now are based on ROR. So this is a very good law, however, it's very limited. Why? Because of its tedious requirements. And then another ways to minimize inputs will be to modernize and expand our probation system. Our probation officers are all here, they are very hard workers. But in the United States, you could have as many times be granted in probation. In the Philippines, you could only use once. Our probation system is very efficient in the Philippines. It has a 2% recidivism rate. So if we put our individuals from jail and prisons to probation, they have a better job of rehabilitating these individuals. Unfortunately, our probation law is very restrictive. It's about high time that we review our probation law and expand it. Also, there's this idea of capacity limits. A jail, for example, designed for 1,000 should accept only 1,000 PDLs. It's like a bed capacity limit for hospitals. And this was introduced to me by my good friend Angel from ICTAB. And they said that if it's 100 bed capacity, you should be stuck to that. Don't accept if it's already beyond that. And as our efforts in the writ of Kalayaan, this could be a very good solution indeed. And then another way is we need to introduce what we call second chance legislation, or clean slate, or ban the backs. Because many of the inmates, when they get released, they find a job, they say, you cannot be given a job because you have a criminal history. In Brazil, for example, according to my good friend Rafa, after 5 years of release, you are given a new slate, a clean slate. You don't have to repeat that, what we call continuing punishments. Now, aside from minimizing the input, there's also a push for what we call fast-tracking the throughput. Right now, we need to have additional courts, prosecutors, and public attorneys to address vacancies. Of the more than 2,700 courts nationwide, in our data we found that almost 25% of our courts right now are vacant. And it's even worse in Mindanao, where in some regions it could reach as many as 50% vacancy rate. And if there's no judge, there will always be postponements. So we are pushing for the notion of judges in waiting. It's very similar to the notion of judges at large, but the idea is once you have already been vetted properly by the JBC, then you should already be considered a judge in waiting. And then, of course, efficiency in organizational court practices. And we are very lucky that we have Judge Banwar here, who will be sharing his experiences on how to manage his calendar effectively. So hopefully we could learn from all these best practices. All right. Also for fast-tracking the throughputs. I've been helping with Director DG Katapang here, and we've been introducing the notion of small, manageable prisons. The Bilibid is the biggest mega prison in the entire universe. Right? 30,000 inmates in that one little complex. Kahit magtambling-tambling ang mga Bucor officers po natin, mahirapan sila. But we have been pushing that there should be small, manageable prisons in Luzon, Visayas, and Mindanao that adheres to the principles of effective prison management. As mentioned a while ago, there should be an integration of our correctional agencies. The jail, it has BGMP and provincial jail, plus the Bucor, plus the boards of pardons and parole and probation agency, they are catering the same people. But sometimes their practices and their activities are quite disparate from each other. Ibang pamamalakad po ng BGMP sa pamamalakad ng Bucor. So inmates start like naninibago po silang muli, right? And there's also lack of integration in our documentation efforts. So yung data mo from the BGMP may not necessarily immediately transfer to the Bucor and may not even immediately transfer to the boards of pardons and parole and probation. There are efforts to integrate that, but still we need to make that even more effective. Also, we need to modernize and expand our parole system. So we need to streamline the procedure for application. I've interviewed so many inmates, and the process from the day of application from parole up until the time that you have the results is 5 years. Ang bagal po ng ating parole application. In fact, right now, the DOJ had already submitted 2,000 recommendees for pardons and executive clemency, but still there are many struggles on how to get those approved. Okay, so if we could fast-track these mechanisms, it's easier. Finally, we need to rationalize the GCTA law. The GCTA law is a very progressive law. Unfortunately, because of the GTCA for sale controversy, nagkaroon po tayo ng maraming problema on how to implement it. And so right now, the Bucor is at a loss sometimes. Iko-compute na ba namin to? I-award na ba namin to? Or we should wait for clearance from other officers. And so, for example, the Reading Your Way Out program will be a good way to be implemented in our jails so that you have more credits for the GCTA. So in a nutshell, this is what we found, right? So the input will be most on the purview of our law enforcement. How aggressive the police officers, the NBI, the PADEA, the Bureau of Immigration. And if they are very aggressive, without regards to the quality of the cases they file, then we will be overwhelmed with cases. The throughput now will be how fast they are being processed in the system. If they are very slow, then it will lead also to jail congestion. And so there should be coordination with the courts, the judges, the prosecutors, and the PAO, and also with the BGMP jails and the provincial jails. And then finally, the output. We need to maximize our output. What we found in our research is that if we expand parole and probation, the money we save will be taken from the population of the inmates. And it's more effective and cost-effective in reducing, in rehabilitating these individuals. Of course, the Office of the President, OP, and the Boards of Pardons play a lot as well. So, in a nutshell, what do we say? First is that we need to rationalize our criminal justice system policies. There are many things that we do in our criminal justice that are what we call self-inflicted wounds. Tayo ang kumuha ng napakalaking bato na pinukpok natin sa sarili natin pong ulo. We use detention as the last resort, and we use our jail facilities and prison facilities to the deserving, most deserving individuals, those who are likely to reoffend. We cannot build our way out of the problem. In America, they went into an imprisonment construction binge. Build, 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 build. What happened? Build and it shall come. Why? Inmates keep on coming. And then after a few years, boom, there's over-incarceration, right? So, while we do build up of our facilities at the moment, the more long-term solution is to minimize the input, fast-track the throughput, and maximize the output. It should be evidence-based. That's why we are introducing case and document management in the BGMP, the Bucor, and the PPA. More focus, more rehabilitative, less costly in the long run, and it will increase public safety and trust to our legal system. And so today, our trust is basically putting all our brains together. We have breakout sessions. We have experts from all over the world who will share their experiences in our today's sessions. And I speak of this research in behalf of all the inmates who are languishing in jail. I am Raymond Narag. I was once an inmate in the Quezon City Jail. I was accused of a crime I did not commit. I stayed in jail for 6 years, 9 months, and 4 days, only to be acquitted later on. I know the consequence of jail congestion. I have lived through it. It has always been my passion, ever since I got acquitted, to study this. And now, this is a very great opportunity. And share it to you all guys. Our success will show that you could rescue many more Raymond Narags languishing in the jails in our countries nationwide. Thank you very much for your time.
Thank you very much, Attorney Abitria and Dr. Narag. As many of us here are aware, Raymond spent 6 years in Quezon City Jail in pretrial detention while undergoing trial for a criminal case for which he was eventually acquitted. It was during those times that he saw for himself the situation of our jails. And that's when we were visiting him in jail, the Christ Youth in Action of the University of the Philippines. And for now, we will proceed to the next part of our plenary session to present the chairperson of the JSCC Technical Working Group on Processes and Capacity Building and chairperson of the steering committee of this National Decongestion Summit, will present the jail decongestion concept note of the JSCC. A warm welcome, please, for Supreme Court Associate Justice, the Honorable Maria Filomena D. Singh.
Thank you. Thank you. Good morning to everyone. Before I start my presentation, I just want to thank all of you, each of you, for being here today. You've heard the messages earlier, but I want to repeat how important this event is not for us, but for the people who are in our prisons and in our jails. So thank you for giving your time to this, and especially for our experts who had to fly long distances, our international guests, maraming salamat. Thank you to all of you. I would also like to acknowledge in particular Senior Associate Justice Leonen. Judge, this is a very rare instance because si Saj is very busy, no, and very hard to invite, but he is here and he's staying with us. And after me, he'll have his session. So thank you to all of you. You heard the two experts, si Professor Iok and Dr. Narag, talk about the problem. So they presented to you what is the problem that we are facing. Dr. Narag also related to you his own experiences and made very concrete suggestions. So this summit is different because we're not just going to talk and then go back to our respective places of work and forget about what we talked about today. This time, what we are doing is different because right at the very start, after presenting to you the problem, we are presenting to you the JSCC's concrete plan of action. We already have a plan of action, and that is what I'm going to present now. Now, how will this plan of action be affected by what will happen today and tomorrow? The discussions today and tomorrow will inform the execution of the plan. If there are certain programs that are surfaced today and tomorrow that are better practices than what we have in the plan, then we will either include them or we can replace what is in the plan that we are going to present to you today. So the objective is that the council wants that at the end of the two-day summit, we are going to execute the plan of action already. So something will come out of this, and we will report to you in 3 months' time, in 6 months' time, in 9 months' time, and in a year's time, what our accomplishments will be. We acknowledge the Chief Justice of the Philippines, Chief Justice Esmundo, who has returned to join us. So let's go to the first slide. The proposed strategies will cover 3 approaches. The first is we want to reduce admissions, in the jails. The second is we want to increase releases. And the third is we want to expand the capacity of jail facilities. When we speak of expanding jail facilities and capacities, we're not just talking about the physical area, no? It's not just about building new jails or prisons, but the capacities also of these jails, no? What do prison facilities need to have and provide for the inmates? It's not just a place where they are supposed to be detained or locked up, okay? And that's what we mean when we speak of capacities. So all the activities that we have are targeted to attain either of these 3 or sometimes all of these 3 if possible, no? And the activities have been grouped under either the short-term plans or initiatives and the long-term. We'll discuss the short-term first. Let's go to the next slide, please. Okay, so the first one is the rules on custodial hearings and the requirement of bail. The lead agency here is the Supreme Court because the provisions on bail are found in the rules of criminal procedure. And the Supreme Court, of course, is the one vested with the authority, the constitutional authority, to promulgate these rules. And we already have a proposed amendment in our Rule 114 in the committee presently revising the rules on criminal procedure, which is chaired by Justice Rodil Salameda, who will also be in a separate session later on in the day. In this proposed rule, what we will now do is that a custodial hearing will be held by the judge for every new criminal case where the accused is entitled to bail. Okay? We know that the number of cases or criminal cases that are filed with us where the accused are entitled to bail, meaning bail is a matter of right, outnumber, di ba, the cases which are heinous where bail is not allowed. And so in that custodial hearing, the judge is supposed to determine if the accused can be subjected to alternative modes rather than physical detention or incarceration pending trial until judgment, no? So, because at present, what judges mostly do is to rely on the recommendation of the fiscal in the information as to the amount of bail. So bail is the only method that we use at present, no? Well, of course, we have recognizance as well, but we know that with the Recognizance Act, it has become very, very difficult because the law requires a sanggunian resolution or ordinance, no? And our detainees, especially the indigents, will not have any means, no, to go to the sanggunian, to the local legislative council, and ask that an ordinance be passed in their behalf, no? So that's practically an impossible condition, and so largely hindi na po nagagamit yung ating Recognizance Act. So that is why we are very heartened that the Speaker of the House of Representatives earlier already mentioned that they will restudy the Recognizance Act, particularly that provision. And so the proposal is that at the custodial hearing, when bail is a matter of right and the accused is in custody, the court will, at any time before arraignment, determine whether it may order the release of the accused after arraignment. Okay, it's important that we arraign them before we release them, and pending trial under such terms and conditions as are warranted. Some of the factors that are to be considered are whether the accused has the financial capacity to post bail in any form, no? Second, if they may be released on recognizance. Third, are they a flight risk and need not post bail? Fourth, are they suffering from some grave medical condition or disability that will be aggravated by incarceration? Fifth, is the accused a pregnant or a nursing mother or the sole parent taking care of minor dependents? Sixth, is the accused of advanced age and incarceration will pose a risk to health and survival? Seventh, is the accused a sole breadwinner of the family and incarceration will leave the dependents without any means of support? And then the last is other similar circumstances. If one or several of the factors are found to exist, the court may release the accused after arraignment and pending trial under any alternative mode to preventive detention, such as house arrest, hospital arrest, compassionate release for the elderly and the gravely ill, furlough for the pregnant women or nursing women, and other similar alternative modes to physical incarceration in a penal facility. Of course, in deciding the propriety, the courts must consider the gravity of the offense, the propensity of the accused to re-offend, if the accused has been accused several times or even convicted, and the severity of damages inflicted on the private offended party or on the state. If the PDL is not entitled to bail as a matter of right, then the rules on a petition for bail shall still apply. So this is the proposed provision on the rules on custodial hearing, which is now being studied by the committee. The second initiative, short-term initiative, is the increased threshold in preliminary investigation and inquest and the prosecutor's recommendation at the custodial hearing. This is, the lead agency, of course, is the DOJ. The Supreme Court's part here is to, in the revision of the Rules on Criminal Procedure, to cede Rule 112 to the Department of Justice, because after all, that is long settled already, that it is an executive function. Of course, the determination of probable cause by the judge upon filing of the criminal information will still be retained. That will not be removed. Here, the strategy is to reduce admissions, and in transition, we will increase releases because the DOJ has also already issued the necessary department order addressed to first-level courts in relation to pending cases where the fiscals are mandated to review the evidence so far presented and to file the necessary motions with the first-level courts in case there is no reasonable certainty of conviction. And for our part, the court administrator has also issued the necessary circular to our judges in relation to the department order. So Of course, we understand how the low threshold of probable cause has caused a deluge of cases, of criminal cases being filed in our courts. Number 3 is to review and remove arrest targets or quotas of law enforcers for specific offenses and review performance indicators. This is on the part of the DILG, of course, for our Philippine National Police, and for the DOJ as well for our NBI. So because it is well known that enforcers in the past have been imposed arrest quotas, and specifically in drug-related offenses. So this practice has unduly put pressure on our law enforcers to carry out arrests, sometimes even indiscriminately already. And so with making merit-based metrics the only standard will, of course, be the solution to this. The fourth is the rule, our protocol and manual on women in conflict with the law. This is a joint undertaking of the entire justice sector. And in the formulation of the manual, we're going for the first time have a manual from end to end. That's going to start from the investigation side, law enforcers, up to the prosecution side, the DOJ, our prosecutors, and then the court side, of course, during trial until judgment, and then during incarceration, and including post incarceration, which is reintegration into the community. We have never had a rule or policy on women in conflict with the law. We are going to incorporate international standards under the Mandela rules and the Bangkok rules. And what is really important is that there be a policy, specifically on women who are particularly vulnerable, like those who are minor females, those who have been sexually or physically abused, pregnant WICLs, nursing WICL, and WICLs with disabilities, as well as elderly WICLs. Also in, I think, September, Akagina, the Committee on Gender Responsiveness in the Judiciary, through the court administrator, issued the necessary circular for the courts to inventory all their cases where the accused are offenders age 60 and above. And they were made to determine if the minimum of the possible sentence has already been served, and orders for their release were issued, and we were able to release a good number of elderly PDLs, not only in September. This is a continuing effort of the Office of the Court Administrator, also through the CGRJ. And then the fifth is to reinforce sector and agency-based monitoring mechanisms for the release of PDLs. This is the part where innovation will really, really help us. It is a known fact that we do not have a digitized monitoring system for our PDLs. The courts have to make do with what we have, manually monitoring. But soon to end with our SPJI, innovation is the thrust. We will automate all our courts. But of course, that is going to take time. But then again, because this is the JSCC, we should think about how the entire sector can share information towards making our services more efficient. And so we understand that the BJMP as well as the Bucor already have their own databases of the detainees that they are supervising. And so there has been a move and a proposal for that information, which is already in a database, to be shared with the courts. Because I was in the trial courts for 11 years, and I can tell you, I never had a case where habitual delinquency or recidivism was used, because we simply have no way of tracking if the accused before us has already been previously convicted, unless it was done by the same court. And so with the database from the DOJ, Bucor, and also from the PNP, BJMP, the courts can now at least have that database and look at the names of the accused who are before them, and they can see if these aggravating circumstances can be used already. This may also solve the problem of our courts where we cannot find our accused we issue the warrant, they cannot be served, they cannot be located, only later on to realize that they are incarcerated in a province far from us. And so our cases get archived, but the accused are detained in another jail. But with that database, once shared with the courts, we will be able to locate our accused, and there will be less cases sent to the archives. Okay. Of course, another thing that the courts have been doing is to put on the face of our case folders the date of detention or date of incarceration, as well as the date when the minimum of the possible penalty has been served. This is a manual monitoring mechanism that we have adopted, our courts have adopted, just so everybody gets to see and be reminded that the accused should already be set free without waiting another day. No? And for this also, the DILG plays an important part because the DILG, BJMP in particular, paralegal officers have done a wonderful job and we have to give them credit, no, for this. Palakpakan po natin, no? Kasi they did this on their own without us asking them. And they are doing this, the paralegal officers of the BJMP all over the country, no? They monitor the dates of release of their inmates, and then they inform the courts, no? They write the courts through the wardens, no? Okay, fifth is to reinforce sector and agency-based monitoring mechanisms already, and for this we have the Justice Zone Transparency Board. This was initially proposed in our Justice Zone in Naga City. I hope EJ Formaran is here with us, no? This was envisioned by Naga City to be a physical transparency board where all the data of the justice sector actors will be posted on a monthly basis. So we see how many PDLs were released by the trial courts in Naga, and then you also see how many cases were filed by the prosecutors, how many also were successfully terminated, etc., etc. Even the arrests, no, and the cases closed by the police will be featured in the transparency board. Now, because the idea was to make it physical, because of our thrust of automation, the Chief Justice suggested that we make this online transparency board so that anywhere in the Philippines, if you want to see how a certain justice zone is performing, you can see it online. And so we will have both, no? We will have the physical in the area, and we will also have it in the JSCC website, the online transparency boards. The other initiative here is the jail visitation and PDL monitoring of our courts, which is embodied in Rule 114 of the Rules of Court, where the executive judges are mandated to conduct their monthly jail visits. Number 6 is to integrate jail decongestion in the clinical legal education program, in the CLEP. No? And here again, the Supreme Court will work with the Legal Education Board and the Philippine Association of Law Schools so that our law student practitioners can be part of monitoring the status of the cases of our PDLs. Our law student practitioners are mostly assigned to help indigent clients, and most of them are PDLs. And so they have actually developed a very, very good system in Cebu City for this. Attorney Grace Casano, I think, will speak. Attorney Grace, thank you very much. Listen to her presentation. It's really wonderful. No, it's amazing. And that is why this summit is really, really very heartening, because all these people who will speak today, and I'm sure those who do not have a chance to speak but will get a chance in the future, are going to share their own initiatives. So this is really a people-based summit. No, it's not everything coming from up and being pushed down, but it's actually what's happening on the ground that we have found to be really effective. Okay. The next one is to also to develop our IEC materials, and I was very happy when Mr. Marchesi earlier mentioned about the Mandela rules and the Bangkok rules being translated in Tagalog, okay? So what we're doing with UNODC is to translate it also in other dialects and languages so that we can propagate the knowledge of their basic rights. The seventh is to strengthen the night courts and ensure 24/7 availability of judges for bail and prosecutors for inquest. This is something that is already ongoing. We're just going to strengthen it, no, through the Office of the Court Administrator again, and through the DOJ, Yusek Vasquez and Yusek Jesse Andres are in charge of this. And the next one is the group of activities that fall under the long term. And you will note, you were listening to the speakers earlier, to his message. I was very happy. I was smiling very, very broadly because everything that we have here for us by way of our legislative agenda, he already mentioned, and he said that he will sponsor it. So the first one, of course, is the study on the classification of crimes as capital and non-bailable, and whether such has had a deterrent effect. No? So first we will conduct the study. Let's see, has it really deterred the commission of crime, that we have classified this as capital offenses, as non-bailable offenses. The next also, he mentioned this, is to study whether it's high time to decriminalize certain offenses. No? And he mentioned libel and abortion and dueling. No? And also to ensure that the imposable penalties are still commensurate to the gravity of the acts committed. We've had several piecemeal legislation, like when we increased the fines, no, for estafa and theft and other related offenses, but we have to do a total or a thorough restudy. The second is the enactment of a law on diversion of adult offenders. No, our law on diversion of children in conflict with the law has proven to be very successful. And so it's high time that we adopt one also for adult offenders. Of course, we will take into serious consideration the gravity of the offenses committed, no, and the number of times that the person has come before us. If it's a repeat offender, then we will of course have a different rule applied to them, no. And then the third is the enactment of the Unified Penology Act. We all know that we have a fragmented penology system. Some of the jails are under the DOJ, that's the Bureau of Corrections, and then we have the BJMP, and then we still have provincial jails under the governors. No? So kaya talagang medyo mahirap po, hindi tayo magiging efficient until we have a unified system. And then the fourth is to enact a law on reintegration and psychological rehabilitation, no? Psychosocial. This is something that the Supreme Court included in its strategic plan for judicial innovations because we acknowledge the international best practice, no? That the best way to rehabilitate is through psychosocial rehabilitation. So simply putting them in jail and even having some livelihood classes, that is not going to be enough. It has to be a thorough, complete rehabilitation. And then the fifth is the amendment of the Recognizance Act, which I already mentioned. We need to amend the act because it has proven to be a stumbling block to this alternative to incarceration. And the sixth and the last is to enact a law constituting the Commission on Human Rights. We have our commissioner earlier, Commissioner Epres is still here, and as our national preventive mechanism. This is something that that has been repeatedly recommended to the country, no, not just to the judiciary, but to the entire country, that we establish our national preventive mechanism in accordance with the optional protocol to the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. I'm very happy to report that yesterday, through the Office of the Chief Justice, the subcommittee of the United Nations on the anti-torture and cruel and inhuman punishment was able to sit down with the court to discuss the court's initiatives in relation to the PDLs, our persons deprived of liberty. So that is our concept note. This is what we're going to do. This is what you will see the JSCC executing in the coming days. And we will come back and come together again after some time so that we can report to you our accomplishments. We hope that you will join us for the rest of the summit and that you will also benefit from the different sessions. Marami pong salamat sa inyo.
you very much, Justice Singh, for presenting the concept note for our National Decongestion Summit. Everything that we have planned for and have undertaken to do in this summit are all for our persons deprived of liberty, or PDLs. The next part of our plenary session is a sharing, a testimony. Our summit will not be complete without hearing and knowing about first-hand experiences. To guide us through this session, we have with us the National Program Officer of the United Nations Office on Drugs and Crime and member of the National Decongestion Summit Steering Committee, Mr. Martin Perfecto.
Magandang umaga po sa kanila lahat. Mananagalog po ako para maiban man ng konti. Bago po natin talakayin ang mga issue at solusyon sa realidad ng umaapaw na piitan sa ating bansa, mahalagang bigyan natin ng boses, mahalagang bigyan natin ng mukha ang mga taong naapektuhan sa mga isyong ito, ang mga persons deprived of liberty o di kaya PDL. Kaya't magsisimula po tayo sa bawat araw ng summit na ito sa kwento ng PDL. Ngayong umaga, si Loreline Carlan ang magkakwento. Nagtagal po siya sa Quezon City Jail Female Dorm ng 8 taon at 4 na buwan. Siya po ay nakwit. Ating pong pakinggan at maya pagnilayan ang kwento ni Ate Lori.
Isang mapagpalang umaga po sa inyo lahat. Totoo po ang narinig niyo po na binanggit po ni Sir Martin regarding po sa akin. Sisimulan ko po ang kwento ko kung paano po ako inaresto. Sabi sa sinampa sa korte, bypass operation. Pero ang totoo, ako po ay inaresto ng walang warrant of arrest. Ako po ay inaresto at kinuha sa loob ng bahay nang walang search warrant. Hindi ko po lubos maisip na ang mandato ng ating mga otoridad ay protektahan ng sibilyan at magpatupad ng kapayapaan. Sa totoo po, disappointed po ako kasi kung dapat sila yung pumoprotekta at tagapamayapa, sila pa yung kauna-unahang lumalabag sa batas na niligay ng Estado. Sa time ng aking pagka-aresto, na-trauma po ako. Bakit? 10 operatiba laban sa isang babae. Lalaban ba? Sa tingin ko, hindi. Mga operatibang pumasok sa bahay na nakasibilya na wala man lang ID o identifications. Kung talaga ba sila ay operatiba o pulis. Na lahat sila ay well-armed. May mga may mga dalang armas. Sa totoo po, kahit ako babae, hindi ako lalaban kung ang kaharap ko may nakatutok na baril sa inyo. Ako po'y kinapkapan ng alam ko po, nalaman ko lang po yung aking karapatan. Ang dapat palang kumakapkap sa isang babae, ay kapwa babae din dapat. Pero po ako, kinapkapan ako ng isang operatiba, lalaki. Ang tanging magagawa lang ng isang babae ay umiyak. At sabi ko ng ganyan, Sir, sasama naman po ako, sabi niya, huwag ka mag-iiskandalo. Kung hindi, isasama ko lahat ng tao niyo dito sa loob ng bahay. Kung ikaw ba ay may threat, maglalaban ka? Definitely hindi. Sige, Sir, sasama po ako. Basta huwag niyo pong idadamay yung mga anak ko. Single mom po ako na may 3 anak. Sumama po ako. Pagdating ko po sa opisina, nakahanda na ho lahat ng ebidensya. Hindi nila nakuha sa akin yun. Sa kanila galing yun. Mula sa pagkahuli ko, sinasabi ko, Sir, hindi akin yan. Manahimik ka. Tinalokbungan ako ng kumot at sinampal. Sinaktan. Oo, maaari maisip natin police brutality. Pero nangyayari po yun, hindi po yun kwento. Nung pagdating po namin sa inquest proceedings, sabing ganyan sa akin, baka akala mo hindi ka babalik sa loob ng stasyon. Kaya kung ako sa'yo, susunod ka lang sa sasabihin namin, sabi ng operatiba. Pero pagdating ko po sa fiscal, nagkaroon po ako ng lakas ng loob. Kasi hindi ko po mapirmahan yung binibigay ng fiscal kasi hindi po akin yun. Nung time na sinabi sa akin, sabi, bakit ka nagrereklamo? Sabi ni fiscal. Gusto mo ba ng lawyer para mag-represent sa'yo? Sige po, gusto ko po. Tapos hinatak nila ako. Sabi ganyan, sir, fiscal, saglit lang, kakausapin lang namin yung akusado. Kinausap ako. Pag gumawa ka ng komosyon dito sa fiscal's office, mananagot ka sa loob ng presinto. Yun po yung nangyari. Kaya pagbalik ko, kinausap din nila yung fiscal, ang sabi nila sa akin, pirmahan mo. Maraming nagtanong, bakit ka pumirma? Hindi naman pala totoo. Kung ikaw po ay may threat, hindi ka ba pipirma? Pagpasok po, naipasok po ako sa loob ng Quezon City Female Dormitory, Quezon City. Maayos po ang pagkakatrato nila doon. Pero po, yung totoo, sa liit po ng kwarto o sa liit po ng selda na meron kami, ang may 300 capacity, umabot po sa 1,500 PDL noong 2015. Natutulog kami sa hallway, kahit ang hagdanan patong-patong. Kahit po yung sinasabi nating round the clock, o sige, ganitong oras ka matutulog, kailangan gumising ka kasi walang mahihigaan yung iba. Kumalat ang sakit kasi magkakatabi kayo, magkakasiksikan kayo. Yun po yung totoo. Naging problema din po namin noon, yung tubig. Isang tent, tatakpan mo ng tela, 50 kababayan, sabay-sabay maliligo. Galing po saan? Sa fire truck. Kasi kinakapos ng tubig. Yun po yung mga bagay na naranasan namin na hirap, na kailangan namin mag-igay para may magamit kami sa panghugas ng plato, panghugas ng aming katawan. Dumating pa po kami sa punto na 1.5 na Coke. Kasama na doon yung paligo at paglalaba mo. Yun po yung hirap na pinagdaanan namin. Pero sa totoo po, habang lumalaon, tumatagal, nagkaroon po ng pagbabago. Dahan-dahan hong nagbago. Nung nalipat po kami sa bagong building, lumuwag po kami. Nagkaroon po ng maayos na tulugan, maayos na lugar. At nagkaroon din po ng maayos na tubig. Habang patagal ng patagal, nagkaroon ng magandang plataforma ang programa ng ating gobyerno sa amin. Katulad na lang ng bawat nakukulong, kailangan nakapag-aral. Totoo po, ignorance of the law excuses no one. At kung hindi alam ng mga taong kanilang karapatan, paano sila maninindigan? Paano nila ilalaban? Nagpapasalamat po ako sa mga provider na pumupunta po doon. Nagbibigay po ng aral para matutunan namin ang mga bagay na dapat namin pinanghahawakan at pinaninindigan. Nakapag-aral po ako at nakapag-aral po ako ng college. Nagsimula po ang pag-aaral ko ng college sa loob po ng Piitan na hanggang ngayon nag-aaral po ako at hinihintay ko na lang po ang 1 taon upang makagraduate po ako sa kursong BS Entrepreneurship. Sa tulong po ng BJMP at ng mga NGOs na pumupunta po doon, katulad po ng HLAF, na siya patuloy pong nagbibigay ng assistance sa amin upang ma-follow up ang kaso. Sa totoo lang po, it's been 8 years and 4 months na nakulong ako. 2017 pa po ako nakaupo sa witness stand bilang sa defense. At inabot pa po ako ng 2023 bago po ako nagkaroon ng promulgation. Ganun po katagal ang inabot ng takbo ng kaso na kinapalooban ko. Nagpapasalamat ako dahil ang paglaya ko, full support po ang BJMP sa akin upang mabigyan po ako ng kahit maliit na tindahan. I was referred sa City Hall sa program po ng No Woman is Left Behind. Binigyan po ako ng tindahan ni Mayor Joy. At patuloy pa rin po kaming ako po minomonitor ng BJMP na wag na pong tahakin ng maling landas. At kung may pagkakataon na magkakaroon po ng mga donations, kami po ang kauna-unahang beneficiary bilang pong parte ng BJMP na aftercare program. At the same time, yung ginagawa po ngayon ng Humanitarian Legal Assistance Foundations, napakalaking bagay po yun. Traumatic sa amin ang makulong. At yung counseling na ginagawa niya sa amin at sa aming mga anak para makabalik kami muli. Kasi napakahirap naman po na after 8 years, magmamando ka sa anak mo, anak, mali yan. Hindi mo masasabi yun kasi sasagot ka ng anak mo ngayon na dating minor de edad na ngayon matured na, nasa legal age na. Bakit ikaw, ma? May sumita ba sa'yo nung ginawa mo yan? So, yung maling kaisipan nila, sa tulong ng HLAF, ng kanilang counseling na ginagawa sa amin, na ilalapit namin ang aming sarili uli sa aming pamilya. Yun po ang pinakauna dapat naming maranasan. Malapit muli kami sa pamilya dahil sa tagal ng inabot ng aming pagkakulong. Kailangan din namin ng counseling. Kaya po, sana, yung totoong mukha po ng kulungan, hindi po kwento yun sa akin niyo po narinig, na lahat ng mga naririnig nyo, ang mga violations na ginagawa ng mga otoridad, ang pagtatagal sa mga hearings, totoo po yun. At the same time, yung hirap sa loob. Sana wag po ninyo kaming ikulong muli sa pamamagitan ng paghuhusga nyo. Because kailangan namin na suporta, hindi lang po galing sa aming piitan, sa aming lungsod, kundi sa inyo din po lahat na makagawa po tayo ng paraan. Maraming salamat po sa inyo.
Dalawang bagay lang po bago magtapos. Unang-una, batay doon sa kwento niya, magandang alalahanin yung, actually hindi niya nabanggit gaano eh. Maliban doon sa pag-aaral niya sa kolehiyo, naging paralegal po siya. She went out of her way, she took the initiative of learning more about law that she could use. In fact, I think that was the outcome that she was acquitted. Pangalawang punto, magandang tingnan din, ang pagkabilanggo po, dahil matagal na po akong nakasawsaw sa mga bilanggo. Ang pagbibilanggo po, hindi po habang nabibilanggo ang epekto ng pagkabilanggo. Ang epekto po ng pagkabilanggo ay lumalampas. Pati sa paglaya. At mismong nakwento ni Ate Lori, na patuloy yung pakikibaka. Patuloy yung kahirapan. Yung kwento niya tungkol sa mga anak niya, yung relasyon. Kaya, doon na po magtatapos sa maiksing baginan po ni Ate Lori. At maraming salamat po, Ate Lori. Maraming salamat po.
Maraming salamat po. Si Mr. Perfecto po ay dating ng taga-Bucor. At Ate Lori, salamat din po. Hindi na po tayo makakapag 15-minute coffee break kasi narinig ko nagkape na kayo. I will now provide important information regarding our parallel workshop sessions because we have our work cut out for us. Your Honors, for this 2-day summit, there are 4 parallel workshops, and in each workshop, there will be 4 groups. Thus, we have a total of 16 workshops. When you registered this morning, you were given a sheet of paper indicating your respective workshop groups. Each workshop group is assigned a room on the 2nd floor. We will be using this ballroom for workshops 1, 8, 10, and 14. The rest of the workshop rooms are located at the 2nd floor, namely Onyx and Jade rooms, workshops 2, 6, 9, and 16. Citrine and Emerald rooms, workshops 3, 7, 11, and 13. Amethyst room, workshops 4, 5, 12, and 15. The first parallel workshop is happening after this. Workshop 1 will be in this ballroom, so for those assigned to Workshop 1, please remain in this ballroom. Workshop 2, please proceed to Onyx and Jade rooms. For those assigned to Workshop 2, aalis na po tayo dito. Workshop 3, Citrine and Emerald rooms at the 2nd floor. Workshop 4, Amethyst room also at the 2nd floor. Kung hindi po nyo alam kung saang workshop kayo, nasa screen din po. At sa labas, there will be ushers holding up signages to guide you to your respective workshop rooms. Your respective attendance will be checked at each workshop room. The parallel workshops will begin now. Thank you so much. Uulitin ko po, pumunta na po tayo sa breakout sessions. We will use this ballroom. Ubus na po yung lakas ko. We will use this ballroom now for our workshop here. Please proceed to your respective ballrooms now. I will also turn over the microphone to the moderator of the Parallel Workshop 1, the Honorable Ronald Martin of the Court of Appeals Associate Justice po. Justice Martin, please.
Good morning. I think we will start in 5 minutes as soon as the other participants have left this ballroom. With respect to the participants of this workshop 1, kindly go in front and fill up the tables in front for our first workshop, which is entitled Proposed Innovative Judicial Remedies for Decongestion and Monitoring Places of Detention. In 5 minutes. 2 minutes. 2 minutes. So in the first minute, kindly advance towards the front, everyone, every participant. Our first minute has ended. Second minute, kindly advance in front. Sit in the front pews. Ako dito lang ako. Dito. Pag People, settle down. We will start in a few seconds.
Check, ready. Testing.
Tatawagin ko muna. Okay, so I will start while you're advancing and give a brief introduction to our first workshop, which I've said is in your program, Proposed Innovative Judicial Remedies for Decongestion and Monitoring Places of Detention. I'd like to call in front the panelists. our reactor, Deputy Director General Pereras from the Bureau of Corrections, and our second reactor, Superintendent Paulino Moreno, Regional Director of BJMP Region 3. Are you people ready to listen to our very first interesting topic for workshop number 1? Okay, let's start. Okay, let's give a listen. Everyone, please settle down, sit down. We're ready whenever you are. Our main speaker in this workshop is a renowned jurist the UP community is very proud of, and he's a proud UP alumnus himself. He's not here to discuss the inevitable UAP championship later this afternoon of the UP Maroons. Instead, he will discuss and talk about how those marooned, quote-unquote, in incarceration and detention facilities can gain access to legal processes in precisely this detention and incarceration facilities, as well as efforts of the Supreme Court to enhance such processes like the writ of amparo, writ of habeas corpus, writ of habeas data. We have reactors here, as I've mentioned, from the BJMP and the Bureau of Corrections, who will benefit and us benefit from their qualified reactions of our main speaker, who needs no further introduction, really. So, without further ado, our main speaker for today, Senior Associate Justice Marvic Victor F. Leonen of the Supreme Court.
Maraming salamat po, and thank you. Looking at the audience, I know that I can be brief because I think I have already convinced you even before I start. And I know that even General Katapang will agree with me now on this proposal. So I prepared something, 4,000 words, but knowing that the time period is very short, I will go off script in order to be able to explain the salient points of the proposal. I have something to offer as a concrete, creative, innovative, pragmatic, judicial remedy available not only for this court, but for a future court. Not only for this administration that is cooperative with the initiatives of the Supreme Court, but any future administration which might not be as cooperative as it is right now. You know, the judiciary is different from the political administrations. The political administrations change every 3 or 6 years. The judiciary, because of the tenure of its members, lasts for a longer time. And whatever it promulgates in terms of ratio, then doctrine, then canon, or rules of court can last for a long time. And therefore, what I propose is something that complements what has already been presented by my colleague, Justice Monet Singh, as well as the changes that are being proposed in the House and in the Senate. If they pass, it is important that there is a monitoring mechanism on the part of the court to maintain that our jails will no longer be congested. As I present this, I must also acknowledge what we all know, that decongestion is the tip of the iceberg. We have further problems apart from decongestion, part of which is going to be addressed by legislation, but the other parts are part of our political economy. For example, the question which you all know can always be asked, and that is, why is it that in our jails, it is only mostly the poor that are there? Diba? Ngayon, when you try to answer that, you will open a Pandora's box of not only the rules of court, not only how law enforcement is done, not only why our laws are such as they are, but also why we treat people who are poor that way. And the reason for decongestion is actually sometimes easy to identify. And I will summarize 5 reasons. Okay, the first reason is because people there are invisible, literally, invisible from the public. This summit is the first of its kind. It is one that highlights, puts a light on this problem. But how many summits can we do every year? How many summits can we do every quarter? In order to highlight the fact that there are people who are sleeping the way that it was presented here, the way that Manang Lori said, the way that judges know, the way that jail guards actually know. So first, they are invisible. And because they're invisible, there must be a way for the invisible person to be able to file a petition in court so that the court can command that a certain light can be shown upon them, other than a decongestion national summit. The second is the attitude that we have for prisoners. And I'm glad that it is changing, because the attitude we had of prisoners before was brought about by our dominant penal system or penal theory. Why do we punish? Normally, number one, retributive, vengeance. Okay? Now we are going to rehabilitative, and hopefully in the future, more restorative means. And restorative means reintegration, forgiveness from the offended party as a condition for parole, forgiveness as a condition for any form of clemency, and so on and so forth, so that the community can actually heal. But further than that, restorative must also mean a society that does not reward being in jail. Alam natin yung sinasabi ng iba, buti nasa kulungan, kahit nahirapan ako, may 3 beses ako makakakain at may nag-aalaga sa akin. Sa labas, hindi. And therefore, when we start to address these full-blown problems, it is easier for us to address the tip of the iceberg, decongestion. So we're not going to solve that now. What I'm just saying is that there are these problems and that there are these causes. Third, it's difficult to make our jails humane because it will take several administrations. It will not take only the BBM administration to be able to make our jails compliant with the minimum detention rules of the Mandela rules or the Bangkok rules. Imposible, sa tingin ko, the way that government moves. And I have been in government for such a long time, 11 years in the Supreme Court, many years in the executive branch of government. So it will take many more years. And therefore, it's important that we leave behind a judicial remedy just in case we are no longer here, so that a single individual who lives like Manang Lori a while ago can get a lawyer, sees this rule, and tries to make use of it. Okay. The fourth one is, the fourth reason why we are decongested, our definition of what we should criminalize. And I am glad that we are now moving towards re-examining some of our crimes. My favorite is PD 1602, Cara y Cruz. Paborito ko yan. Kasi palagi kong tinatanong, why is it hindi pwedeng i-franchise ang Cara y Cruz? Pero yung Baccarat na high rollers, pwede mo i-franchise. Why? Again, why punish them? And recently, the Chief Justice penned a decision declaring null and void bladed weapons in carrying it in occasion of an election offense. And it was almost unanimous. Only, I think, one dissent to that opinion. My other, of course, you've heard of buy-bust, hindi ko napapaliwanag yun. And lastly, the archaic procedures that we have. And this Supreme Court, under the present composition of that Supreme Court with our Chief Justice, is attending to that. That's why we have SPJI. Shortly, and I mean shortly, I think baka next month, if I'm not mistaken, we will have revised rules of criminal procedure which will have very important amendments, which includes yung bail, which Justice Monet has said, and also which may include many other things that many of the experts have already identified. Then, digitalization. Okay. So those 5 things, unless they are done, will contribute to the congestion of our jails. So that's ongoing. So if I may be allowed an analogy, yan yung natural childbirth, di ba? Mahirap yung natural childbirth, masakit. Okay? However, just in case, there are people that die in jail, that suffer in jail, Almonte versus people, that get COVID because everybody is together there, then there should be a remedy that will allow for a cesarean-like solution. In other words, force a solution to make the jails more humane. Okay, is this possible to be done by the Supreme Court? Via a rule of procedure? And my answer is yes. Let me demonstrate, number one, to tell you that the writ of kalikasan, the writ of continuing mandamus did not require a statute. Did not require a statute. It did not even require a clear provision in the Bill of Rights. It only made use of Article 2, Section 14. The state shall ensure a healthful ecology in accord with the rhythm and harmony of nature. Yeah, memorize ko yan. Kaya kami nagtatap ng bar, usually. Okay. Usually. But to explain, we are not bar-oriented. Okay. No, but the point there is, it did not need a statute. It needed a Supreme Court that said, there are certain rights to be enjoyed by our citizens which are not the subject of political accommodation. We will not throw it to the political departments. We are saying that there is a right to ecology, and this is the procedure. The substantive right is already embedded in the Constitution. Okay, to convince you further, Article 3, Section 1, it will be flashed here. Not that I did not memorize it. Para lang makita nyo. Article 3, Section 1, Due Process Clause. No person shall be deprived of life, liberty, or property without due process of law. Okay, my question to the lawyers here. Where do you find there the distinction between substantive and procedural due process? Wala, di ba? All it says, due process of law. Life, liberty, property. Walang nakalagay, you divide it into fairness and arbitrariness. And fairness and arbitrariness, here is what substantive due process means. Tapos, gumawa pa ng tatlong test, di ba? Reasonable, relation, intermediate, strict scrutiny, na pinag-aawayan namin madalas sa present Supreme Court. But it's not there. You know why? Because the Supreme Court has said that there are certain minimum rights, like reasonableness of laws, that we will be the one to flesh out, again, because it cannot be the subject of political accommodation. It cannot be the subject of this money, do we put it into confidential funds or put it into certain kinds of projects, like beautification projects, or should this money be put into our jails in order to make it humane? Therefore, there has to be certain provisions which the Supreme Court said are not or cannot be the subject of discussion in a political arena. And if it is a right, then therefore, all the other departments must find a way to fund it, to give it resources, because otherwise, we will not be the state that we envisioned it to be, allowing for liberties of certain individuals. Okay, now, with respect to our jails, are there provisions? Yes. Let me start with a very general provision in Article 2. And this is right in tune with this week, kasi International Human Rights Day. And this is the provision that says, the state values the dignity of every human person and guarantees full respect for human rights. Okay, two parts. The first part is a statement of values the dignity. But the second part is more powerful. The state guarantees. Who is the state? Executive, legislative, judiciary. So the judiciary guarantees. And guarantee means something proactive. It does not mean passive. Okay? Pareho dun sa, no person shall be deprived of life, liberty, or property, nor shall any person be denied equal protection of the law. Passive. Pero Section 14 ng Article 2 sabi niya, the state has the duty to ensure the fundamental equality between women and men. So mas positive yon. This one is couched positively. This is constitutional provision. This is not hortatory. It cannot be hortatory. It cannot be non-self-executing. To me, human dignity is self-executing in itself. And all of us agree because all of us are advocates. So it's already there. Okay, if you're looking for a specific provision, lagay natin yung Article 3, Section 19. It has two parts. The second part, 19, Section 19. Okay. Here. Nor cruel, degrading, or inhuman punishment inflicted. Okay? Wag muna tayo dun sa second, dun tayo sa first. The first and the second are independent of each other in my reckoning. So the first says, you cannot impose a cruel punishment. When you do impose a cruel punishment, the state immediately comes in. The second is degrading or inhuman punishment. That is what the 1987 Constitution introduced. How do I know? I was part of the research team that actually wrote this provision for one of the commissioners, Rene Sarmiento, and then the committee participated in the discussion. And I know for a fact, it went beyond cruel, degrading and inhuman punishment inflicted. Okay, now, there is a second provision which says, subhuman inadequate penal facilities shall be dealt with by law. Okay? So that means that we should have a standard. And do we have a statutory standard? And the answer there is yes. Minimum detention standards, Mandela rules, international law, Bangkok rules, di ba? And we even translated it. Why did we translate it? For our detainees. Because we know and we accept that they are binding on us. Okay? Then furthermore, obviously, if a law has not been passed and there are still subhuman conditions, what should the court do? Should the court simply throw it to the Congress and says, hintayin namin kayo? Whereas in truth and in fact, our trial court executive judges, soon all trial court judges, the chief has already ordered all trial court judges to have visitorial rights. Ang sakit nun. Okay? Let me just emphasize to you. What I'm going to say will help our jail guards. Okay? Have you heard of the Stanford Prison experiment? What happens to an individual who has the power within a jail who sees inhuman conditions every day? What happens to them? Okay? I will tell you what happens to them. They lose their humanity. They lose their humanity. Sa kanila ordinary, na meron siya nakikita maliligo, tigda 2 bote ng 1.5 liters. Yung sinabi ni Manang kanina. For them, it's normal that people sleep around the clock. Yan yung nangyari sa jail guards. It has something to do, it affects their psyche. And I am not surprised that there could be superintendents that are so inhuman that they can take a knife and simply stab the hands of those that they feel they do not like. I'm speaking theoretically, General Katapang, okay? Although, siya nagkwento sa akin, theoretically also, yes, okay. But the point there is, again, it will help the guards, okay? And do you know how it feels to be a warden? When you are a warden and you see the conditions of jail, okay? And you are so helpless kasi binibigay sa inyo, eto lang ang pera ninyo, eto lang ang resources ninyo. And kayong tinatamaan, nakikita ninyo, umuwi kayo sa bahay ninyo and then you tell your children, you are there to make jails humane, but you have no resources. Kawawa kayo. So this remedy is for the wardens also, the jail guards also. Okay, I'll go briefly. Humabon versus Director of Prisons. What happened there? The subversion law was repealed. Kapepe Jokno filed a petition for habeas corpus on the theory that habeas corpus can be a post-conviction remedy. What does that mean? As soon as subversion law was already repealed, the reason for Humabon being in prison has already been illegal. And therefore, habeas corpus, di ba? Kasi illegal detention. He won. He was released. Okay? Now, if you are in jail and your conditions are so subhuman, can you call it cruel, degrading, inhuman, and therefore file a petition for habeas corpus? To me, yes. Subject to proof. Okay? Subject to due process. But to me, yes. I mean, if you cannot sleep 8 hours a day because there is no space, and it's 2,700%, as the chief said, congested, ibig sabihin, in a square space, for 10 individuals, there are 270, tama bang math ko? But in any case, the point there is, yes, okay. But what's wrong with Humabon versus Director of Prisons? Paisa-isa. Paisa-isa. And you do not address the problem. And the problem is that the facilities are not changed. What you do is release them one by one. And swerte yung makahanap ng abogado. And usually, nakakahanap ng abogado, mga Humabon. Okay? And I can tell you the history of Mr. Humabon. But only people that can find somebody else. Okay? So we need an extraordinary remedy, again, that will not replace all these initiatives dito sa natural childbirth natin. It will not replace all these initiatives. It will complement it. Okay? And I suggested this in a separate opinion in Almonte versus People. You know, ang kwento ng Almonte versus People, if I may share, it was a very long discussion by the Supreme Court justices. Ang haba. Ang daming ideas. And in the end, sabi na lang namin, sige, wala nang ponensya kasi wala tayong ma-agree upon. Therefore, only a resolution and sangkatutak na separate opinions. And I am so happy because law students will have to read very long cases. Yan yung isa kong dream when I was a professor, to become a Supreme Court Justice, to write very long ponentias, okay, for the law students. But the other point is, again, the reality is that there is no remedy that can compel everybody to come together for a particular jail. And therefore, we suggested the idea of a writ of kalayaan. Okay, it is not my idea alone. Hopefully, it's the idea of everybody here. Hopefully, it's the idea of the Supreme Court. I do not care about attribution because you know the reality. You will never remember, nobody will ever remember all of us. But somebody in a congested jail will fully appreciate all the efforts that we put in. They will not remember, sino bang nagsabi nito? Sino bang JSCC dati? Sino bang presidente dati? Sino bang nasa Supreme Court dati? They will not remember that. And therefore, this one I offer to all of you. And it's a very simple idea. And what we did was simply remove all the procedural details. There are more details in the current draft. But I removed all the procedural details so I can show you the flow chart. Very easy. It's just 4 parts. The first part is that there is a filing of a petition by any detainee. Okay? And the detainee will only say that they are living in subhuman conditions. Okay? Hindi i-release kaagad. Hindi bubuksan yung preso para lumabas yung mga heinous criminals. No. Okay? Of course, by this time, there is now a supermax and there is a non-supermax jail, hopefully, because of the law. The next part is, it's collaborative. Therefore, government has to provide an answer to challenge number 1. It's not subhuman. We have already met it. We are in Marawi, ang ganda ng facilities, for example. But they can also say, we are in Quezon City, eto nga yung totoo nangyayari. Okay? They will say, they will either admit or they will challenge, and they are required, if they admit that it is subhuman, to present a program, and coordinate first with all the relevant agencies. Here is our game plan. Okay? Now, if the petition is sufficient in form and substance, it will go ahead. If it is not sufficient in form and substance, the court can immediately, motu proprio, simply dismiss it. Okay? Kasi ang dami nagsusubok, syempre, magpa-release. And to dismiss it does not mean that they cannot be released. So to dismiss it can mean mag-compute ka ng GCTA mo, magsubok ka ng probation, etc. Or ang bagong concept ng bail, etc. Okay, but the other point, of course, is that if those are not possible, we proceed. With the plan presented by government, okay, the Supreme Court or the court itself will look at the plan and Upon agreement of the parties, if there is agreement, or if there is none, issue an order similar to a writ of continuing mandamus for the environment. You know, the writ of continuing mandamus, Environment Manila Bay, the only benchmark was clean up Manila Bay. That was the only benchmark. And we are moving towards going to hear that case to make it more strict. Ano ba talaga hinahanap natin dito? What do we mean when we say clean? Here, we already did that. Specific, measurable, attainable, reasonable, time-bound goals. And there will be milestones. And the court will only act to check whether the executive and the legislative, the LGU, if it is a local jail, okay, is complying with it. And yan lang yung role ng court. Okay? Walang nare-release. But what happens is that we put a spotlight on the jail. We call attention to the need for resources. We do not provide the resources. The court does not provide the resources. But the other parties are now having to put 10 million here, 100 million here, etc., to be able to complete it. Okay? That's the heart of it. What happens if they do not comply? The court orders an order for an order of release. What is an order for an order of release? Okay. The jail warden will now have to submit to the court how it's going to release, transfer prisoners so that it becomes a humane prison. Okay, in other words, the release will only come after an order of priority is approved by the court. Dito na isasama, ito pwede na, GCTA. Okay? Ito pwede na, tapos na yung kanyang minimum sentence. Ito pwede na, maximum of capital punishment, 40 years, etc. Okay? So the point there is, at the end of it, if it is not complied with, the court will force that the jail be decongested already, writ large. Not one by one, but the entire jail itself. Okay? And government, therefore, will have to say, we are going to transfer this there, etc. Can you imagine? We are going to transfer 10,000 of the prisoners or 1,000 of the prisoners to this prison. When they did that, another writ of kalikasan on that prison. And then so on and so forth. Anong mangyayari? We are now going to truly reform our penological system because there is now a supervision made by the court. Okay, I will repeat. This is not, will not, never replace all the current efforts that we are doing right now. And all the current efforts now are really different from 2-3 years ago, I could say that. Okay, ngayon with JSCC and all the cooperation of all the branches of government, we're doing very well. Okay, so that there was a position paper which said, meron ng batas eh. Meron ng batas. You don't need to do this, Supreme Court. Fine. Therefore, pasalamat kayo, meron to, kasi may remedy. In other words, if you do not follow the law that says, here are the standards for humane conditions, somebody can file this so that the court can supervise it. This is just a remedy. It does not create the rights. What created the rights? A substantive right, to me, the Constitution, basically. Second, our statutes. Third, our commitments to international law, which by Article 2, Section 2, and Article 7, Section 22, Treaty, Article 2, Section 2, customary international law on human rights, makes us bound already by it. That's all. Yan yung writ of kalayaan. Okay? It is not to release all political prisoners. It is not to subsume the judiciary to become the legislature. It only creates the remedy, similar to amparo, habeas data, writ of kalikasan, continuing mandamus, habeas corpus. And let me just tell you, habeas corpus of the first type was invented by a court years ago. It did not come from God. It did not come from the legislature. So my question now is, will you support a court that now knows that there is congestion in our jail and provides this remedy, not as a threat, but as a way to assist those that are suffering? Okay? And again, I will repeat, hindi lang yung taong nasa loob. yung mga jail guards natin. Okay? And you know how you feel when you know that there is somebody being tortured out there, pero you do not look at it. You forget it. Magti-TikTok kayo. Di ba? You go to Twitter, you forget all of it. There is something in you that eats up on your humanity that will trigger you at some point. Okay? I will tell you, those that have come from incarceration for the longest time, they cannot live a life without finding a way to help people that are there. You saw Dr. Narag here, okay, and many others. And again, this is to help those in jail, those who are jail wardens. We also want to assist our trial court judges because we want them to have their complete humanity and to know that if it does not happen, pag nakikita nila 1,000% yung kanilang detention center doon, they are in charge of it. They will not just say, wala akong magagawa, ganyan talaga, it's separation of executive, etc., etc. Judiciary cannot do anything. So this is a proposal and I offer it to this summit to support it. Maraming salamat.
Thank you very much, Justice Leonen. Our first reactor, I will appoint from the Bureau of Corrections, who I'm sure will not make any correction. Deputy Director General Pereiras, can you first react?
Good morning, sir. I would like to thank the distinguished Senior Associate Justice Marvic Victor Jonen for the presentation, for the enlightenment. In fact, the writ of kalayaan was forwarded to us for comments about 3 months ago. And we have we've taken some comments, we consider some comments, especially this includes the comments of the Secretary of Justice, who has administrative supervision over the Bureau of Correction. First, it is undeniable that jail congestion is the perennial problem in the country's prison system. The Bureau of Corrections could not deny the fact that at present, there is overcrowding of PDLs in all our jail facilities in our country, most especially in the new Bilibid prison in Muntinlupa City, which at present, the PDL population is 29,442 for a capacity of only 6,435 PDLs. The present administration through the Bureau of Correction has already initiated measures to address the concerns and issues regarding the PDLs by decongesting our prison facilities, upgrading its existing facilities and creating new ones, and also uplifting the living conditions of the PDLs in accordance with Republic Act 10575, which is the Bucors Modernization Law. Other measures are being undertaken, which includes the release of PDL either through the grant of parole in coordination with the Board of Parole and Pardons, and also we recommended those who are over 70 years old and those who are terminally ill are being recommended to the President for executive clemency. One of the innovative remedies presented by the Honorable Justice Jonen is the proposed passage of the writ of kalayaan, which is intended to release a person deprived of liberty if the court finds the facility fails to rectify or improve the condition. This is either through bail, recognition, or probation, regardless of whether the PDL is detained during the pendency of trial or to serve sentence. The said writ will be anchored on the Supreme Court's power to promulgate rules concerning the protection and enforcement of constitutional right. The constitutional right intended to be protected in the present case is the PDL's right against cruel, degrading, or inhuman punishment and the use of substandard or inadequate prison facilities under subhuman conditions as initiated under Section 3, Article 3, Section 19 of the 1987 Constitution. Although we recognize the difficult situation faced by the PDL because of overcrowded prison facilities, we believe that the alleged substandard conditions in our prison or detention facilities do not amount to violation of Article 3, Section 19 of the 1987 Constitution. In the case of People versus De La Cruz, GR number L-579T, dated 17 April 1953, the Supreme Court explained that prohibition of cruel and unusual punishment is generally aimed at the form and character of punishment, such as the inflicting of whipping post or the burning at stake or disemboweling and the like. And imprisonment will not be within the prohibition. Clearly, imprisonment per se is not cruel, degrading, or inhumane. And as such, Article 3, Section 19 of the 1987 Constitution cannot be used as a justification for the proposed rules. While the current state of prison facilities or detention facilities may not be ideal, their conditions, however, have nothing to do with the punishment imposed upon them, which is imprisonment. Neither the proposed rules can rely on Section 19, Paragraph 2, Article 3 of the Constitution, as the latter expressly states